You know, every country has its own story about how it defines itself, what it values, the promises it makes to its people. For Canada, a massive chapter of that story was written back in 1982. It's the story of how a nation decided to create a definitive rulebook for rights, and in doing so, it literally changed the country's DNA. But before we jump into the details, let's chew on the big question that's really at the heart of all this. Who gets the last word when your basic freedoms are on the line? Should it be the folks you vote for, the politicians who can change laws with a simple majority? Or should it be judges who are appointed to interpret a higher, more permanent law? That's the core tension that the Canadian Charter of Rights and Freedoms was built to address. All right, so to really get this, we've got to jump in the time machine. To understand why the Charter was such a game changer, we first have to see what Canada actually looked like before 1982. What was the deal with civil rights back then? And here's the crucial thing to understand. It's not that Canadians didn't have any rights. They did. But those rights were mostly based on tradition and regular old laws. See, Canada had inherited a system from the UK called parliamentary sovereignty. In simple terms, this meant Parliament was king. Any right that was given by a law could be taken away by another law, sometimes with just a simple vote. Nothing was permanently safe from the politics of the day. Now, they did try to fix this back in 1960 with something called the Canadian Bill of Rights. But it had some pretty serious problems. As you can see here, it was just a regular federal law, not baked into the Constitution itself. That meant it only applied to the federal government. The provinces didn't have to follow it. And maybe most importantly, the courts were, well, pretty shy about using it. It just didn't have much bite. And wow, this right here just drives the point home. Think about that. 22 years. And in all that time, the highest court in the land used the Bill of Rights to strike down only one law. This timid approach, as it was called, made one thing crystal clear. If Canada wanted real, muscular protection for its citizens' rights, it was going to need a much, much stronger tool. Okay, so that sets the stage for the big moment. This brings us to a landmark event in Canadian history, the patriation of the Constitution and the birth of the Charter. This was the answer to all the weaknesses of the old system. Yeah, this didn't just happen overnight. It was a long, bumpy political road. You have that first attempt back in 1960, then after decades of arguments, a real breakthrough finally happened in 1981, when almost all the provinces got on board. And that led right to 1982, when the Constitution was officially brought home from the UK and the Charter of Rights and Freedoms became the highest law in the entire country. And that brings us to this really important word, entrenched. This, right here, is what made the Charter a total game changer. Unlike that old Bill of Rights, which was just another law, the Charter was woven directly into the fabric of the Constitution. That meant politicians couldn't just change it or ignore it whenever they wanted. To change the Charter, you'd need a huge national agreement, putting these rights way above the everyday political squabbles. So what happens when you do that? When you entrench these rights and make them the supreme law? Well, you get a massive power shift and a brand new supercharged role for the courts. And this new power is called judicial review. Before 1982, this mostly just meant courts deciding if a government was stepping on another government's toes. But after the Charter, judges got the power to put any law on trial against these fundamental rights. And if a new law clashes with one of those rights, a judge can just say, nope, this law is invalid, it has no force or effect. And look, don't just take my word for it. This is from one of Canada's top constitutional experts. He called it extraordinarily active judicial review. This wasn't some tiny tweak to the system. It was a seismic shift. The floodgates basically opened, and courts transformed from just being referees between governments to being the primary guardians of our individual rights. And the proof is in the pudding, really. Since 1982, the Charter has become the main event in Canadian constitutional law. It's totally transformed the legal battleground, putting the rights of citizens front and center in a way that had never happened before. But the Charter's impact goes way beyond just the courtroom. It's also had a huge effect on the country's very sense of itself. It's actually been a powerful glue for national unity. So how can a piece of paper do all that? Well, for one, it created one set of rules for rights that applied to everyone, no matter where you lived in Canada. It guaranteed your right to pack up and move to another province for a job. And maybe the biggest thing, it kickstarted these huge national conversations about our deepest values. What does freedom mean? What does equality look like? It gave all of us a direct connection to Canada as a whole, not just to our home province. Okay, so right about now, you might be thinking, wow, so the judges have all the power now, right? Well, not exactly. And that brings us to the last and maybe the most uniquely Canadian part of this whole story, the compromises that were built right into the Charter itself. This is such a key point. Charter rights are not absolute. In the real world, my rights can sometimes bump up against your rights or against big societal goals like public safety. The people who wrote the Charter knew this, so they built in a few checks and balances. The Charter basically has these two big escape hatches, or safety valves, built right in. First, you've got Section 1, the Reasonable Limits Clause. This lets the government limit a right, but, and this is a big but, they have to prove in court that the limit is reasonable and justified. Then you have Section 33, the famous and controversial Notwithstanding Clause. This gives politicians a power to essentially say, thanks for your opinion, court, but we're going to pass this law anyway, overriding certain rights for a limited time. So what you end up with is this really unique Canadian balancing act. It's not total power for the judges, like you see in the United States, and it's not total power for the politicians, like in the UK system. Instead, it creates what a lot of people call a dialogue. The courts can say a law is unconstitutional, but the politicians, using these built-in tools, can respond, and sometimes even have the final say. And that brings us full circle, right back to where we started. To protect our rights, the Charter gave an incredible amount of power to unelected judges, but it also kept a door open for the elected governments to push back. It's a uniquely Canadian model that legal experts all over the world study, but the debate is far from over. The question is, did Canada get that delicate balance between protecting rights and respecting democracy just right? That's something every new generation of Canadians really has to answer for itself.